is the director of the Bulch Judicial Institute at Duke Law School. Before his retirement from being a judge, he was the district judge of the U.S. District Court for the District of Maryland, and he is also an Army retiree, Lieutenant Colonel. So, Honorable Grimm, I'll just hand it off to you, and thank you so much for being here with us. Thank you.
Thank you all. When you clap before someone starts, they should just leave the room because they can only go downhill from there. It's a pleasure to be here. I want to start off with a word of thanks for all of you who are working in the government sector. There's a lot of press about the government workforce that we've seen in the last few years. A lot of it hasn't been accurate or hasn't been charitable, but I know that any success that we have as a country is built on the work and the dedication of all of you who are in government service and who spend your time and your efforts on behalf of all of us. I want to thank you, especially our colleagues here in the uniformed services for what they do. So thank you very much. You're going to see a lot about the power and the opportunity and the extraordinary ability of artificial intelligence. You all know that. I'm here to talk about a very narrow sphere of where the artificial intelligence that you know and deal with every day intersects with the legal system. And there's a lot of ways in which the legal system is struggling to deal with AI. Some of it deals with how do we as judges use it, what's appropriate, what's not appropriate. There's a lot of issues about how should lawyers use it. You've seen cases about lawyers citing a case that turns out to be hallucination and doesn't stand for what the premise was. The American Bar Association has recently promulgated 16 pages of guidance on ethical use of AI in the legal system. But what I want to focus on is when you all are all doing what our first speaker, who gave such a wonderful motivational speech about get in there and do it, and as you use these tools for doing the work that you do in your agencies or in your companies, eventually it's going to end up in some fashion or another in an issue that's going to present itself in a court. And so I want to talk about what is the lens through which the courts will look at evidence that is generated by or in part influenced by the use of artificial intelligence systems. In doing that, let me just say that the legal system is small c conservative. It moves very tiny incremental steps. And not only that, but it's based upon sort of an accumulation of one case deals with one aspect and that becomes a building block, and then another case kind of expands it and you build from that over time. We also have rules of practice and procedure that deal with how information can be presented in court proceedings, whether they're civil or whether they are criminal. And to get a new rule of practice or procedure from concept to reality can take as much as 5 years. Now, technology, of course, does not change much in 5 years, right? So you can actually have a situation where by the time you have a rule designed to deal with a type of technology, that technology doesn't exist anymore. So these are sort of the realities of which we are in. Some of these slides I'm going to go by very quickly. I'm quite confident the slides will be available if you want to have them later, if you find them useful for something other than causing you to have the sleep that you need when you wake up in the middle of the night. But let me just talk about sort of various aspects of artificial intelligence. What do we talk about when we mean AI? And I think most of what is the hot ticket item today is generative AI. And you all know what generative AI is. Generative AI is AI systems and software that are trained on enormous amounts of data. Some of it might be something like the entire internet. Others might be something which is sort of a bespoke sealed system of information, like all of the cases ever decided by the federal courts or all the cases ever decided by the state of Maryland, or some other sort of a contained environment in which the information is all verified information. How it's used in response to a prompt is depends. But there's also artificial intelligence. And what I like to tell people is all generative artificial intelligence is artificial intelligence, but no, not all artificial intelligence is generative artificial intelligence. And as our first speaker told you today, AI has been around for a long time. In one sense or another, it was around in the 1940s and 50s when the Dartmouth conference sort of first started talking about it. And we're really talking about the use of technology, software applications, algorithmic systems to do things that previously only humans could do. And generative AI has that spark of what we were talking about in our first speaker's presentation, which is the ability to have this dialogue, to have a prompt, and to have the AI go out and to look for the response. The reason why we have to be cautious about this is that there are certain types of software applications that will search for a right answer. But when you're using generative AI, in the absence of some built-in aspect of this technology that verifies what it's doing, it's not looking to get you the right, true answer. It's looking to predict what the language would be to respond to your query based upon the database that it has based upon. So it may come up with information that it believes is the prediction of what would be the response to the prompt that you have based upon all of the information that it has searched for that may or may not have relevance to what you're dealing with. So it's not looking for the right, true answer. It's looking for a statistical prediction of what should be the response to the words that you've used in your prompt. And generative AI, at least on the legal scene, I've been writing opinions as a judge and writing law review articles as a professor about technology and artificial intelligence since the early 2000s. And the first I ever heard of generative AI was when ChatGPT-3 came out in 2022 or 2023. So all of the focus is on this just technology that has only been around for a few years. What the current models of ChatGPT and these other models that are out there by other systems as well, it has made remarkable progress. And there are, and the investment in AI research is unbelievable. You probably know AI can do different things. AI can be broad. It can do a broad range of things. It can also be narrow or weak. Weak being it can do one thing really well. So if you have an AI system that can play Go better than a human or chess better than a human, the general or strong AI or AI that has the ability to equal or exceed human concepts and human ability. 5 years ago, people were predicting that would not happen in our foreseeable future. Now, with some of the computer developments that have occurred, there's not so much confidence that we won't have situations in which we would have that concept of what's referred to as singularity, where AI is equal to or greater than the ability of the humans who are using it. But right now, it is a tool, and it's a tool that has some remarkable pros, and you have to be careful of what the limitations of its use are as well. It's been used everywhere. I mean, the fact that we have all of you who are involved in the intersection of government and technology here from the various substantive areas where you do your work is evidence of the fact that AI applications are being used everywhere in our society. They are literally, cannot avoid the use of artificial intelligence. It's in healthcare, it's in education, employment, finance, in law enforcement, government, in the military. This technology has exploded, and it will continue to explode. The uses, when properly used, are remarkable. So what are the key concepts here? The courts try to break things down. What is going on? Well, these are software applications that are algorithmically controlled, and an algorithm is nothing more than a recipe. So if I tell you how to bake a chocolate cake, and I tell you the ingredients you have and the order in which you are to use them, and the temperature that you're supposed to bake it at, and how long, and what to do afterwards, that's a series of steps that are designed to be done exactly as they were stated in the order in which they were to be stated, and you get a result which is a predictable result if you do it every time. The difference is that a recipe for a chocolate cake probably takes 2 or 3 index cards. I have had cases where the software applications for the AI had millions of lines. And in fact, generative AI, one of the things it does pretty well is to do software coding. So we are now in a situation where the complexity of what these software applications can do is enormous. I mean, think about the ability of a tool to search the entire internet. And be able to come up in the time it takes for you to hit enter, for it to say 1 moment please, and then it starts to scroll down an answer, and the answer is crafted in ways that have such a confidence and such a completeness and such a logic to them that it almost seems as though you have tapped into the modern equivalent of the Oracle at Delphi. And from the point of view of the law, the key issue is always going to be when you have used this. If you have used this AI to do whatever you're doing, let's say you're doing it to determine whether somebody is entitled to Social Security disability benefits based upon their medical records and their explanation of why they're disabled, or you're using it to see whether somebody should get a student loan, or you're using it to make a prediction as to whether or not some incoming signal on a radar screen is a threat that needs to be countered quicker than the human ability to go up the chain of command, or needs to be taken care of immediately. When you're dealing with things like this, the key issue from the law's point of view is, how do we know that it does what it is supposed to do? There are two concepts that come into this, that when we'll see how they break down in terms of how the law interacts with the use of AI when it is involved in a controversy that the courts are being asked to resolve. And one aspect of our society is pretty soon every aspect of our life, whether it's history, whether it's religion, whether it's education, whether it's politics, whether it's science, whatever it may be, sooner or later some aspect of it gets brought into bear in a court action. Oftentimes you might find, for example, that if you're using artificial intelligence software to come up with regulatory actions in the government, there could be a challenge under the Administrative Procedure Act as to whether or not the basis for that information is arbitrary or not arbitrary. So we worry about validity. Does it do what we say it can do? Is it accurate? But accuracy is not enough, because you've all heard the expression that a broken watch tells the correct time twice a day. You also need reliability, which is consistent accuracy when the product is used under similar circumstances. And that is an issue, at least with some generative AI applications, where you've got to be careful. Because depending upon how you draft the prompt, you can make essentially the same prompt 4 or 5 times and get different answers each time. So that learning curve about doing it in a way so that you've done it enough to where you can rely or have the information that you can then look at to try to verify before you take that next step of baking it into some use that might potentially be second-guessed by someone who's affected by that particular use. And so reliability and validity are two twin terms that the courts are increasingly being asked to look at when someone says, Judge, we did this based upon the use of this technology, and this is an appropriate outcome, and someone else says, no, you can't do that. And I'll give you an example of something that the courts have tried to wrestle with where AI technology was used. There was a software application called Compass, which was originally designed to try to predict whether or not a person facing criminal charges based upon their background and their prior criminal history would commit a new crime while they were waiting for the case to go to trial. It was done originally for the purpose of allowing courts to say, well, if we give this person an ankle bracelet and we give them anger management and drug counseling and mental health treatment, then they'll make it to the trial. We don't have to lock them up. And because recidivism is something that's relevant not to just whether they are released before trial, but is also relevant to how long a sentence they get if they're convicted, it morphed into being used for purposes of deciding how long a sentence to give. And as it turned out, when this software finally was able to be accessed by a person challenging it, that it had a tendency to have, which is sort of like the worst possibility you can have. It produced both false negatives and false positives. So there were some real problems in the way in which the data was trained. And part of the problem was, even though it did not try to ask questions directly related to race, there were questions that were racial proxies. Where do you live? What zip code? Has anybody in your family ever been arrested for a crime? And if you look at these kinds of questions, they correlate very distinctly with racial demographics in the population. Same kind of problems that have occurred. Recently, there was a decision in the Intermediate Appellate Court in Maryland where they reversed a conviction in a robbery case where the police department used facial recognition technology to identify someone from a surveillance video that then led to an investigation, which led to a search warrant, which led to a lineup, which led to them being identified, which led to them being convicted. And there was a duty on the part of the government to disclose that to the defense because the defense requested it. They did not do that. And they said, but we won't introduce evidence. We won't introduce to the jury that we use this facial recognition technology and that these were the pictures that it picked up. but they didn't give the underlying information to the defense attorney to challenge. They couldn't even remember what it was, and they no longer had it. The Intermediate Appellate Court said this is a violation of their due process rights, and the conviction was tossed out. So the notion of how these things work and whether they're doing what they were supposed to do is something that is also fits into the kinds of questions that will be asked when this software gets into work. What does it do? Well, you know what it can do. It can classify, it can rank, it can predict. It has amazing powers of being able to analyze and to be useful. What are some of the issues that come up when you see AI being used in court? Well, bias. Sometimes it can be intentional bias, but many times it's unintended bias. There can be a bias baked in. For example, if you use facial recognition technology and you've trained it on all white men, it is not going to do as good a job in terms of doing facial detection of people who were not in the training set that it was used for. Lack of robust testing. Many of these AI software applications are proprietary. So a company comes out, they spend time, they do the R&D, they do the testing, they know when it does good, they know when it does bad. They are the ones that revise it once the test results preliminary came in. They come up with it, they then go out and license it to being used, maybe to the government. And in that licensing agreement, it generally says you cannot allow someone else to have access to this to be able to test it. That's a violation of our licensing. And initially the courts were saying, yeah, you can't have access to it. And more recently, the courts have said that's just not fair. You can't have it both ways. You can't use this technology and say we're going to use it for this purpose, but when it's challenged, not produce it to the other side. So you have a choice. Either produce it under a protective order so the other side has an opportunity to kick the tires on it and find out whether there's a basis for challenging it, or I'm not going to let you use the product of it. And for those of you who may be dealing with licensees, if you have that license agreement in your license, you better have a conversation with them saying, you know, if we use this software and we get dragged into court because of it, there's going to be a demand to be able to have access to this by the other side. And proprietary information and confidential commercial information is not a basis that says you can exclude it from discovery. It's a basis for a protective order to prevent it from being available to a competitor. So if you have something that says you can use it but you can't disclose it, then you have a real limitation in terms of how you can use that if you're using it to do things that might cause events to occur that would get you into court about the use of this technology. What are the evidentiary issues? Because my primary concern is you've got technology, it's been used, you're basing your position in a court action on this being sufficient for the use that it was designed to be done. So what are the rules of evidence that will govern whether or not the court allows the jury to hear that information? So the first one, since the evidence rules are technology neutral because it takes so long to get them changed, they don't talk about a particular type of evidence in most instances. But there is a rule, Rule 102, that says, you know, you can flexibly use the rules of evidence so that if you don't have a rule that specifically deals with a situation, you can analogize to another rule that does exist. And that's important because when the courts have been trying to deal with artificial intelligence evidence, what they have done is borrowed from the rules of evidence that deal with scientific, technical, and specialized information, and that's the expert witness rules. And said that things, and we'll see a slide on that in just a bit, such as is it based upon sufficient facts and data? Are the methods and principles used to get the output, are they reliable? Have they been reliably applied to the facts of this case? And that concept of reliability gets into some of the Supreme Court decisions that say you look at whether it's been tested, is there an error rate? Is the methodology used generally accepted by people in that science or technology area? Are there standard protocols where they complied with, and questions like that? So we'll see about that. In addition, the rules of evidence are very clear to allocate the job of the judge from the job of the jury. And the judge is a preliminary screener of evidence as to whether the jury gets to hear it. But the impact of the evidence, whether it's believed, whether it is used by the jury to reach a decision or rejected, rests with the jury. And now there can be trials before judges alone, but the basic model and the assumption of our rules of evidence is that they are jury-centric, that a jury will be making these decisions. And there are some important rules that say that if one side says, for example, this software will do X, and the other side says, no, it won't do X, it's only going to be relevant if the party that wants to use it can show that it does, within certain parameters, successfully enough accomplish what it says to happen to be relevant. Because if it doesn't do what it purports to do, it's not relevant, and if it's not relevant, the jury shouldn't hear it. But if there are disputed facts about whether it does it or doesn't do it, the law says that the jury has to be the one to resolve those facts. So the proponent comes in and says, well, here's why it's valid and reliable. The opposing side says, here's why it's not. And the jury's supposed to resolve that. But they're in a battle of wits unarmed because they don't understand any of that. Because the only time that science and technology is allowed to come in is when the jury needs help with something that they can't figure out on their own. So the rules have this baked-in dilemma, which creates a problem, particularly with the ability of generative artificial intelligence to produce very realistic and hard-to-detect deepfakes, which is sort of the dark side of the ability to be able to use this generative AI. With about 90 seconds of audio and visual of somebody, you can use these tools that are available for almost no cost or very little cost to come up with a deepfake, making them appear to do or say anything you want them to do in ways that are so realistic that even computer scientists tell you that they have a hard time determining whether they're fake or whether they're real. And psychological studies have shown that the public, when they see things that they think are actual videos or audios, they believe it, and even if they're told that it's false or it may be false, they cannot unremember it. It has changed the way they look at those facts. So these are some of the issues that the courts are trying to wrestle with, and we'll talk about that in just a second. Key concepts, it's got to be relevant. It has to have a sufficient ability to do what you say it does. The good news is that's a low barrier, 51%. That's like a coin toss, right? Just slightly better than a coin toss. So it's a low threshold. Rule 403 says that if it's relevant and therefore ordinarily a jury should hear it, if it's unfairly prejudicial, if it may confuse or mislead, or if it will have a tendency to sort of undermine the ability of the jury to figure it out, then even though it's relevant, it should be excluded. The judge makes those determinations of prejudice and exclusion, not the jury. Authenticity is the key evidentiary concept. Does it do what you claim that it does? And there are many different ways in which you can show authenticity. And Rule 901, which is up here on the board, 901 says is if you show more likely than not, by preponderance, it is what it purports to be, then it has sufficient reliability. And there are multiple ways of doing it. You can do it by calling a witness who has the expertise to explain how it is that this software does what you say it does. Mind you, this is not someone trained how to use it. All right, you may be trained very well how to use a generative AI tool, but if you're not, that's not the person that needs to authenticate it. It's got to be the person who knows how it was developed, trained, tested, the data that it's based upon, and how it was tested and what the outcome of those tests were. That's the kind of thing that's going to be necessary to decide whether or not it is sufficiently reliable to be authentic so that a jury or a judge can rely upon it in deciding a case. What I have told you about is that one of the ways in which you can authenticate is by calling a person with expertise, and that would be someone. Now, and the benefit is that in the legal system, we only have two flavors of witnesses. We have lay witnesses, people who saw it, heard it, know it from personal experience, right? And we have experts. Lay opinion testimony is based upon personal observation and knowledge. Experts can base their knowledge on other information, even if it's not as self-admissible, as long as it's reliable. So the way in which you're going to get this type of evidence in 9 times out of 10 is by calling an expert who is not testifying solely on their own personal knowledge, but based upon information that is reliable that they got from other sources that's reasonable for them to rely on. And that is the kind of information that will allow the legal questions of, has it been tested? What is its error rate? Is that error rate acceptable for the use that you're using it for? Has it been subject to some sort of analysis or discussion in the literature of that science or technology? Are there actual protocols that say we all agree that if we're using this technology, we do it in this order, and did they comply with that? And those are the kinds of things that the experts will be called upon to decide. The key notion here is that when you are undertaking to do this at a court proceeding, you can't use generalities. You've got to have specifics to be able to do it. And it goes necessarily, it's true, that in order to be able to do this, someone's going to have access to this software to be able to test it independently to determine whether it lives up to what it's billed at being able to do. Now, the court will readily issue a protective order so that so that the competitor of the producer of that software doesn't have to worry about it getting out. And those things can be pretty sophisticated and pretty protective, with a lot of different barriers in there to make sure that the cat doesn't get out of the bag in the course of the litigation. There are some rules that will allow you to authenticate this kind of information in a fashion that you don't have to call a live witness if you have a certification from someone qualified to do it. But there is a proposed evidence rule 707 that's out for public comment, where the Rules Committee for the federal courts have said, look, if you have computer-generated evidence, which is going to be broad enough to cover AI, and if you're going to offer it with one of these certifications without a live witness, if you were going to call a live witness to testify as to that, then that person would be governed by the expert witness rules, Rule 702. Then that certification is not going to be enough to get it admitted into evidence, even though there's a certification that can be taken, unless it shows that the expert's qualified, that the information would help the fact finder, that there was sufficient facts and data. And when you're talking about big data devices, you're talking about what is that data that they were trained on? Is that sufficient? Are the methods and principles reliable and accurate? And were they reliably applied in this particular case? Those are going to have to be shown. And so my rule of thumb is, if you can answer those questions in a way which are all positive, then you have a very good chance of being able to cause the court to say, this is good enough. Doesn't have to be perfect, but it has to be at least this good before it can be considered in the output of that case. As I mentioned to you, the most important concept is whether or not it meets those threshold requirements of validity and reliability. And many of you may have heard of the Daubert test. It's a test that the Supreme Court came up with in the early 1990s for a different type of evidence altogether. But most of the states now, over 60% of the states, have adopted this standard. The federal courts have it. And this is a notion that if it's scientific, technical, or specialized, that you look at the information, its testing, its error rate, whether the people in that scientific or technical community would say this is the proper way to develop this, and whether or not they followed procedures that were recognized as the proper procedures in the proper order in order to get results that are sufficiently reliable. Now, I want to stress that reliability is not perfection, right? And when we're talking about error rates, there is no universal error rate. So, for example, if someone says that the error rate of using this software application is 80% likely to get an accurate result, 20% not likely. Well, there are some applications where people would say, well, 20%, that's 2 out of 10 times. It's wrong. We can't rely on it. But if the next best alternative is a human being to do that, and they are wrong 60% of the time, then which is a better option? The machine is going to be the better option. But there is a aversion to technology. So, for example, how many Americans are killed in automobile accidents because of negligent driving? Hundreds of thousands a year. But if you are making a self-autonomous driving car and you have one accident, then it's like, oh my gosh, this is terrible. We expect perfection. And those sort of a double standard when we're looking at machines versus individuals is still something that the law sort of struggles to deal with, and frankly, society at large. I talked to you a moment ago about new rule 707. This is a rule which is proposed for public comment. It may or may not be approved, and if it is approved, it would probably be 2 years from now. But if it is approved, what it will do is it will say for machine-generated evidence, and the law sometimes likes to use broad phrases, lots of machine-generated evidence that is not necessarily generative AI or AI, although a lot of it will be, and it will cover AI. that you are going to have to be able to show qualifications of the person explaining how it works, that understanding it and using it will help the outcome of the case, that the data it was trained on is sufficient for its purpose, right? That the methods used to make this software work the way it does are reliable, and that notion of reliability builds in validity and reliability, and that people in that discipline, science, computer technology, that's the kind of reliability that they would accept. And those are going to be the standards. And so what my takeaway to you today would be, if somebody's in there saying, well, we've got to produce this software application, it's going to be evidence in a case, then what are we going to have to deal with? What might we have to explain? These are the things that you would have to explain, and this is where you want to be able to identify the people within your team who can do that. I will skip over some of these now to say that one issue that is still working its way through the courts is what happens when the user of the software has licensed it from the developer and the developer doesn't want it to be available to be tested. Pretty much the standard response to the courts now is you got to produce it for the other side to have the ability to challenge it. We'll put a protective order in place. There were some early cases, the Loomis case in 2016, where a state high court said, no, you can't have access to it. And that resulted in a response that was probably a deprivation of due process on the part of the defendant. That was in a criminal case, and I will tell you that courts are particularly careful to make sure that in a criminal case where someone's liberty is at stake, that there is a fair opportunity to be able to challenge evidence offered against the defendant. Deepfakes are particularly problematic because they are increasingly so good and so realistic, and psychological studies have shown you that there are real challenges when people are exposed to what they believe are simultaneous recordings, audio-visual of events that took place, and they are unable to unremember that even if the judge were to exclude it. Why am I saying that? Our first speaker made reference to the White House artificial intelligence plan that was rolled out about a month ago. If you look at pages 12 and 13 of that report, it says deals with concerns about protecting the legal system from the impact of deepfakes. It is now predicted that there are 500,000 deepfakes put out on the internet a year, and the speed with which they are coming out is even greater. I don't know who comes up with these statistics, but somehow it did. Probably use generative AI to get it. But so the White House has said there is going to be a proposal that the Department of Justice is going to urge rules committees and other court proceedings to adopt a rule similar to proposed Rule 901C. Rule 901C was a draft rule that the Evidence Rules Advisory Committee crafted in a meeting this last May based upon a proposed rule that I provided to them along with a colleague who I write a lot of my papers with, Professor Maura Grossman. We proposed a different version of 901C. And the version that we offered was not the one that the committee decided that it would put on the shelf if they needed one for future use. They used the first 3/4 of the rule that we drafted, but then changed the ending of it. But what it says is that if someone is going to challenge evidence as a deep fake, you don't want someone just to stand up and say, Judge, how do we know this is genuine? Everybody knows that there are deep fakes out there. Everybody knows that you can get access to this software and use it. And how do we know that wasn't done? That is not evidence. That's just argument and speculation. What I refer to that as the lions and tigers and bears objection, right? There's no evidence to support the fact that it is. Someone's just trying to muddy the waters. That will not be sufficient. The party that wants to challenge the evidence will have to come forward with some evidence that shows that a jury could find more likely than not that it's fake. What might that be? Well, let's say it's supposedly a voicemail message from me left on someone's phone communicating a threat. You can have the time of that voicemail message. What if I can produce 5 witnesses that I was in, or 30 witnesses that at that time on that date I was standing in front of a bunch of AI experts and talking about AI, and therefore I couldn't have done it at the time that it was supposed to have been done. That might be evidence. It may be expert analysis of it that suggests that it was fabricated. And then what would happen is the proponent would have the ability to bolster their evidence by showing that it was not unreliable, and the judge would then make the call as to whether or not, more likely than not, it was authentic, and the judge would make that call. So what this proposed rule, while the Evidence Rules Committee decided just to put it on the shelf and not even put it out for public comment, I suggest that that may change because the White House AI battle plan said at pages 12 and 13 that the Department of Justice was charged now with trying to work with all of your agencies to try to make sure that a rule like this was adopted to prevent fakery from interfering with the fact-finding, truth-finding mission of the courts. To me, that's a little bit of an interesting thing because when the Evidence Rules Committee voted, it was the Department of Justice representative who voted not to go forward with the rule. Perhaps the White House plan has changed their order of priority now, and it may well be that the Evidence Rules Committee will go forward with that for public comment. So I'm not going to go on with the remaining slides because I got to be getting close to my time. And if there are questions, I want to have an opportunity to answer them. But I have in the slides, if you have them available, the rule that I originally proposed with my co-author, Professor Grossman. I put it in there for comparison because I think that the rule that we originally proposed addresses another evidentiary issue in the existing rules of evidence that the proposed rule doesn't address. But if I was told we're not going to use the rule that you did and we'll have no rule or the other rule that the Evidence Rules Committee came up with, I'd say throw me under the bus and go with what the Evidence Rules Committee did. So in wrapping up, let me just say this evidence is unbelievably powerful. The ability of what these tools are for and what they will be in the near future continues to just advance at exponential speed. It's being used everywhere, and the investment in it continues to go. But you have to use it like any tool. There are people who look at sophisticated technology. Some of them look at it as utopian. The world is going to be wonderful. We'll all be better. Others look at it as dystopian. It's the end of the world as we know it. It's actually just topian, if that's a word. It's neither dystopian nor utopian. It depends upon how it's used, how it's designed, how it's tested. And those are going to be the kinds of questions that increasingly are going to be asked when the product of this magnificent technology finds its way into disputes which find their way into courts. So thank you very much, and if there are any questions, and I still have some time, be happy to answer it. Talk you into a stupor.